Raise this finger, please. How about the charger? Please hold the cases that stand down the judgments that I run through my lips. Yes. Any matters for second? Okay. Yes. Shall we? Yes. Always check the payment. If you keep returning back, please. Yes, that's with no ink. Yes. There's no pain. I didn't ask you to come up. There are no friends here. One minute, please. No pens here to write. Please, the jury is of challenges and ensure that the right order. I think that's really criminal. When I have criminal law. Yes. Yeah. Yes. Yes. HCS 2322. No, that's not the one. HCS HC20. Yes.
Respect minority and see why is really assistant director of the institution. Space.
When I know the place, I'm a super, I'm building more life. Appearance is for positive evidence. While I think the quick, Mr. Abayo attack, second evidence.
Can you repeat that, please? Holding brief for who?
This is Abayo attack, for the second evidence.
Yes.
Church. Conspiracy to commit and lawful possession of house. The plea of the defendant are contained in the last appendix.
Right.
Matter is listed for hearing this month. Subjects might not are ready to.
Right. Yes. Can you please speak up?
They are not ready to commit trial. No, about that. Second defendant counsel. It's not aware that this matter is becoming law. It's not just this morning. I put it all through to think that the matter is coming up.
On the last date, 31/24, Isirio in court, Olalekan in court, Abayomi Fatai in court. Case adjourned to 27/3 for hearing. So what do you mean he's not aware?
I called him this morning that the matter.
He does not want to be in court. Case is stood down for hearing. Lineage Council, State Council, you want the matter adjourned? Another date then. Date 24/6. Oh, hear me. Next one.
It's the advent. It says, Akiola to development.
Yes.
My God.
Yes.
A lot of over respect. If FAO
Chief.
FAO
Yes.
with Ayokunle Inawu
Ayokunle.
Akinawu
Aki.
Inawu.
Can you spell that?
N.
Double N.
That's a lot. N AWONU. But it is never.
Right.
This other is now defined. This is who is Akiola. Unfortunately, my mom students before the village go down in like one. Now it is a month. Trial.
Being handled by who?
This is who is Akiola.
Yes.
Unfortunately, my mom students before the village go down in like one. Now the months are coming up to the university. That was the
I don't know why we are not objecting to the request of my planet. But if the point will be made that the defendant has been incarcerated for 5 years. And not only that, the trial judge, four trial judge, retired at the point of nearly delivering judgment. So we're starting dealing with. About to submit that the state should take that.
Right.
What question will be leading for a short adjournment?
Governor State Council. Council handling this matter ought to know that it's important to be. This is a case that has to start de novo. So we have to start all over again. And the defendant has been in custody. Don't go fixing two matters for the same date and then choose the one that you prefer to attend. But it's not right. And if you want to do that, whoever is sent to court should be ready to commence trial. Because most likely you will have in a year, maybe a chance to have the case, considering the workload of the court. 3 days max in a year. This is March. The court is going on vacation till mid-April. And then if we give you June, the court will close July. So you probably just have like 2 days. You have to take that into consideration. Then we get on to the last quarter of the year, and that's it for that year. So when you miss a date, it's very, now will I say this now? To get a short date in this court is difficult because of the workload in SAGAMU. So you're likely to have at best 3 dates in a year. And if we don't take those dates seriously, that's it. Another date then. We're almost closed even for June. Please adjourn to 24/6 for hearing.
It says, I see again.
Yes.
Yes, my Lord. See why this meaning. Appearance mistakes.
Right.
I am here to defend it.
Right. Let's be hear him first. One minute, please. 1 minute. I think of that you were really by the defendant.
Yes, ma'am. And we are next. Our next with 24 January 2020. With letter of instruction.
Our letter dated register. Your letter dated
24th January.
2020 what?
Three.
Yes.
Yes, we are next, letter of which was being signed. Right now, okay.
Right.
So, hopefully, maybe before the next day. So, yeah.
Are you appearing pro bono?
Yes. Very good.
Senate Counsel, Mr. Balogun. Yes.
You know, this month, the fourth person, another busy body of the appearance for dependents.
Right.
And those guys, dependents. Yeah. And he said that.
Are you appearing pro bono?
But then, we're personally protected those. Going to abdominal correction. Oops.
Registrar, has we taken the plea of the defendant? Asking his language of preference. He has two lawyers ready to represent him. Who does he want? You have two lawyers here ready to represent you, free of charge. Hello, fair. Who does he want? That is resolved then. Right. Registrar. Registrar, can we take the plea?
I see that again. What language do you understand? Let's say that's a voice. That's what I see. I think all about the 4th of December 2020 at SAGAMU village in SAGAMU, within the SAGAMU Judicial Division, forcefully entered into the community land with arms and ammunition, thereby placing members of the community out of the land. God is coming. Wọ́n ní ìwọ àti ìtàdéyẹmí ní ìgbà kan ní ọjọ́ ọjọ́ kẹrin oṣù kejìlá ọdún 2020 ní abúlé Lucy Ṣàgámù agbègbè ilé-ẹjọ́ gíga Ṣàgámù wípé ohun bá ti bá wọ àdúgbò ilẹ̀ àdúgbò pẹ̀lú ìbọn àtàwọn ohun olóró míì tí o bẹ̀rẹ̀ sí ní fi lé àwọn ará àdúgbò lọ. Ṣé nǹkan tí mo kà tó yẹ? Ṣé ọjọ́ bí ẹ̀sìn náà àbẹ̀jẹ̀? Ṣé náà fi lẹ́nu ọdún tí wọ́n kà jọ?
Right. Then I say counsel. How many witnesses do you intend to call? Defense counsel, how many witnesses do you intend to call? Date for trial. Register. 26/6 then for hearing. Next one.
ACS 2020. It states, Joy Okoro. Ketunjo. Uju Bebo. Mary. Chukwu. Joy Okoro.
First, we have five, sir. Yes, sir. First to fourth defendants in court, sir.
First to fourth defendants and court, sir. Fifth defendants, sir.
Right. You will need to speak up, learning counsel. All well. Hart as in H-A-R-T. Wahid.
May this honorable court be pleased. T.M. Shofola. I am now appearance for the fourth defendant.
Please, if you are appearing pro bono, always let us know. Are you appearing pro bono? Okay. Right. Any other appearance?
Yeah, just analyze it, in the space of analyzing the representing, reportedly representing the second defendant.
Right.
Yeah, this case is 2022. So if that is the case, we worked out.
Can you please announce your appearance so I can record you?
She FAO
FAO.
super. Why yes?
The ordinarily for the second
With
defendant. With
Ayokunle Akinawole.
for the second.
But the second defendant. The matter of police.
And you have been appearing for the second.
Yes,
for the
since
second.
my colleagues have been carrying since 2022, over 2 years.
Right.
So if he decided to bring someone else,
Are you appearing pro bono?
yes, madam.
Right.
So if you tell this court a preference, we don't mind appearing.
Right. That is who is the second defendant? Let's see. Is that Kate Njoku? Senate Counsel. Kate Njoku. Who is Kate Njoku? Raise up your hand. Who is your lawyer? Speak up. You don't know the person. Nobody has come to you.
And it was just
1 minute, please. Let me check the records. It's actually a good sign that we have lawyers representing the defendants free of charge. And because of that, sometimes they don't even know. But I think it's something that lawyers ought to settle amongst themselves so that we avoid this embarrassment. I mean, you are not taking money for it. You are just doing a service to the country. So it's really, really not a problem. You know, we just need to sort out this issue so that we know exactly who is representing. These cases you are not earning from. So we shouldn't be embarrassed for having enough lawyers to represent these people in custody.
my lord.
Yes.
As I said, my innocence was attending to her. And they
Right.
were
That's
seeing-
why she does not know
and
exactly.
they were seeing her.
But I would like to hear from Mr. Olwell Hart. When did you take up this who are you holding brief for? Wahid Salau. And he's not even in court to state how he got this brief. Has he ever appeared? What? I didn't hear you. When was that? Mrs. E.O. Ojunekon, is she from your chambers? Ojunekon? No.
We keep.
What the second defendant is? This is
I think that, and I think I think that. Although I think beyond that will work out.
Let me just have a look at it. The second defendant has been represented by one Ojunekon. Yes, it's Ojunekon. 2020. Second and third not represented. Obanewa is hereby assigned to defend third defendants. Ojunekon with him, Olubuyi Miss. Is that the second? Who is the second defendant? Is that the said Kate Njoku? Consistently, one Ojunekon has been appearing for the second defendant. Before, I can't hear you, Lieutenant Counsel. And then one Abuja for the second defendant in 2022, when the court opened trial. Is Abuja from your chambers, Lieutenant Counsel? Mrs. A.M. Abuja, holding the brief of Dr. Kwasi Yusuf. Okay. Atunda, yes. When trial commenced, I see. When trial commenced in 2022. And then,
This is 2021.
right, Atunda, SK Yusuf for the second defendant with Mr. SK Yusuf with A.M. Atunda holding brief for Dr. F.A. Yusuf. That was also in 2022. And the case continued then. A.M. Atunda for the second defendant. That's also in 2022. A.M. Atunda, that was in November again. So obviously, and then I think on the last date, Orwell had appeared holding brief, watching brief for Salau. That's all we have here. So the second defendant is properly represented.
But it's not the parents of the job who opt out.
Okay, you want to opt out?
Yes.
But we have not seen Salauddin. It's just been holding.
It's embarrassing. It's embarrassing for a person. For an elder statesman.
The thing is that these people don't understand what's happening. So people just go to them in custody and they believe it's probably the same person. So we need to resolve this because we don't even have representation for some others. This should not be embarrassing because it's a free service. It's not like we are being paid for it. It's a service to the community. So, but we just need to sort this out because from time to time, I think we have pro bono clinics and councils, some go on behalf of MBA and they take off the briefs. Some take off the briefs, to assist. So what I will be concerned about is if these people are paying and then councils are struggling to represent them. But in this instance, it's a problem, but it's a good problem when we have counsel to represent. The woman does not know the lawyer, obviously, but one attorney has been representing since trial opened, and that's probably from your chamber. So we just need to sort out these little issues because the woman doesn't even know anything that is happening. So I don't think you should be embarrassed about that at all. It's free service. You are not being paid for it. What I'm concerned about is Mr. Orwell Hatch holding brief for Salahuddin, who has never appeared in court. Is he a member of the NBA? Is he one of the exos? Because they said they also. So on record, we have the chambers of. So I have noted that on record, we have the chambers of Chief FAO Yusuf representing since trial commenced. So you need to speak to your lawyer in respect to the said Mr. Salahuddin. Now, do we have any other representation for the first? Okay. No representation for the first and third. And no representation as well. The first for the first, the third, and the fifth.
Yes.
Is the fifth on bail?
Suspecting is really SAGAMU for fraud because the mail, others who are female on
Right.
the whole
Right. Okay. So we still need representation for the, who is the third? Do you have a lawyer representing you? What's her name? The third defendant? Please ask her. Would you favor? The fifth. The fifth is absent. The first. Who is the first? Yeah, you're correct. Ask her if she has a lawyer. Can you please check the records and see who has been representing? The last record, the last few, before I took over the case. Can I see? Regina has been represented.
Chief Ishi or Jimmy for the first defendant.
The third,
The third.
when trial commenced.
So what was the
Let me have.
This one.
Good enough to put it in trial commenced. Yeah. You follow for the third. Follow and then Chief Regina for the first. Abuja for the second. Then we for facility, PM Tukola for the third. So we had no representation for the fifth. And here again. The state, Virginia for the first defendant. Please put it on the forum today that H.A. Ojiri for the first defendant was not present in court for this case. Not it on the forum. And also, okay, yes, please. So we don't even have any representation for defendant. But we don't have any representation for the on record for the fifth. Make sure the fifth is still Government State Council. Are you sure the fifth defendant is still in this matter?
That's much.
But you need to confirm to us.
Yes.
What happened? First, second, and third. I can see the. Yes, Mr. Shokola.
When this matter was.
Yes. Yes.
We have four.
Huh?
We have four defendants.
Uh-huh.
There is no fifth. Even when trial commenced, there are only four. One barrister turned up to appears for first defendant.
Right.
Appears for first.
So we don't have, okay, so there are four of them. And yes, on record, we have one Chief Ojiri. So maybe that thunderbolt is from, it's not from the same. But he has not been appearing since the case came up. The case came up on the 21/2. We had Ojiri when they came for trial. Also, we also have Ojiri for trial again. So we don't have representation for
On 21st. 2020.
yeah.
That was when trial commenced. 21st day.
Yes, and we had Ojiri for the first defendant. Atonda for the second, and GM Shokola for the third.
That was when there were three defendants.
What?
That was when there were three defendants.
Yes.
For the charge was submitted. Now reflects four defendants.
When was that? When was the charge substituted?
The charge
You said the charge was substituted to reflect.
four defendants.
When was that? These records are not properly updated. Not even we need to get the record of the president. Okay, you see. You send for it. I'm requested for the example of proceeding. You can't see, who is spoke out, you can't see. It's a good. This was fine. It has not been.
This one.
Well, there is an amended charge in the file. I don't know if anything has happened in respect of that amended charge. Planet State Council.
Yes.
I just said something about an amended charge. Are you aware of what is happening in this case?
Appearing in this matter since inception, but so you filing charge for the courts. Because on the matter.
Well, I will not take the plea today because we need to sort out the issue concerning council. I will assign Mr. Owellhart to take the case of the. He does not have counsel. Mr. Wahid will take the case of is it the fourth? The third. Now we have who is Paul Mary? You are appearing for Paul Mary. I'm still confused here. The first defendant is represented by Mr. Ojiri. Record. Second defendant by the chambers of Chief Yusuf. Third defendant by Mr. Shukola. So we don't have representation for the fourth defendant. So Mr. Wahid Salah will represent the fourth defendant. Is that?
I represent the fourth.
The fourth, not the third.
Not the third. The fourth, for me.
That is for Mary. Yes. For Mary here in the amended charge is the third defendant. It has not been taken. The amended charge has not been taken. That is for Mary, right? For Mary. Chief Yusuf, Chambers is representing Kate Ujoku, right? Kate Ujoku. Representation on record for the first is one Mr. Muiwa, is one Mr. Ojiri. You need to put it in the chat. That is still representing the first defendant, so that we can assign counsel. What?
I will search for them. It's full.
Okay, you don't have the telephone numbers. You have to start taking the telephone numbers of counsel in criminal cases. You understand this? So please always inform counsel. So please put down their telephone numbers. But what you will do is to put this on the forum. So. Mr. Ojiri, okay, came out today, and there was no representative. Maybe they will see it. He may not be on record, maybe somebody will. So the fourth defendant, would you favor? Brief assigned to Wahid Salau, represented today by Allwell Hart. The state should be ready with the amended brief on the next day.
That Odu is the Odu that we are in Thunderbolt as well.
Thunderbolt is
I've forgotten his
okay.
name.
Please take note and perhaps collect his phone number. All right. Please, if we don't have you on our list or WhatsApp group, kindly leave your phone numbers with the register. Date.
The fourth,
24/6. Please adjourn to 24/6 formation. Next one, please.
about the department of justice. This says themselves, I think, state. Abiona, Abraham. Abiona, Abraham. Hello.
Right. Defendant
Absent.
absent? Yes. Right.
From our record, from village. We've not been able to get service.
So what do you want us to do concerning that bill? Do you still want to get him to come? Where was he granted bail? Here in this court? At the magistrate court.
And it prevents Warren has been report.
Bail is revoked. Go and get him. Going warrant to issue. Right. Date. Please adjourn to 24/6. Right. Is it Ogunobi or Ogunbiyi? Is it Ogunobi or Ogunbiyi?
So fún mi sà.
Right.
Lọ́wọ́ sà, ẹbí tí bàbá yìí. Alájà Kúndínláàtù kò sí ní. Mo yí àbùjù. Múrítàlá Ọlálẹ́kọ̀ọ́. Isa Ọládiméjì àbúrò. Honorable Bashir Ọládùnjoyè àbúrò. Títọ́lá àbúrò. Falsat Ọlápẹ́jú àbúrò. Mr. Michael Ogunkan. Aṣíwájú SK Ọmọfowópamọ́.
First, third, fifth, and seventh claimants present. Other parties absent, sir.
Right.
You see at the value of the claimant. Very good.
Yes.
Amen.
S.A.
Amen.
Amen. With age. For
For defendants.
all the defendants. How many do we have? Two. Afolabi. Right.
The process before was the deep
I didn't get you. Bernard, counsel? Yes.
We have filed our own
What?
we filed our own statement of defense with the contact with the flag.
You are for the,
Therefore, the claimant.
you filed what?
We filed our flag with the defendant statement of defense and contact with.
When?
It's not enough. And we have already filed our amendment.
Bernard, counsel for the defendants?
Yes.
If it's filed today, it won't be in the records. Yes. Yes. What is this about? Land. I see. Any attempt to resolve the matter out of court? Not likely to be resolved.
The family attended
Right.
the
Parties who file their PTC forms then.
you have taken steps.
You have all done that. Learned counsel for the defendant. Date for PTC. Parties shall attend court on 27/6 for PTC. 26th of June. Right. right. Anything else? We don't have the file yet. For number 13 and 14.
Yes,
and
yes, they are not.
the file.
They are still at the.
Are they here? Is council here for Anthony? Are you here? Then call the case. If you don't have the file.
It's not here.
You don't have the file. ACS 10822. And are the parties in court? Handling management and AG. ACS and
This year's
this one, ACS 542.
And this year's 108. Simply,
The same payment.
yes, ma'am.
How far have you gone at the multi-dom? What? Speak up. I know you are exploring settlement. I said, how far have you gone? What? Yes. It's ongoing. Okay, because we still have the files there, so we can't take your appearance today. I hope you'll be able to settle out of court so that we can file the report. We'll give another date for these two cases. What date?
37, my lord.
Cases adjourned to 3/7, both of them. All right. Yes, yes, I'm taking that after this.
All right.
Let me run through the other ones. Yes,
Olúwa ṣeun ẹ̀gbọ́n wa Ayọ̀ Sáyẹ́nsì. Ọdún Ayọ̀ Akíbọ́lá Sáyẹ́nsì. Dámilọ́lá Mary Ọmọṣaléwá Ọmọlò.
is there a third party cited?
Yes, sir.
Parties,
That's awesome.
representation?
Yes, sir.
This is not out.
What,
Right.
that was during this, my lord. That's,
Have they been coming?
yes, they are making it. I thought they
Another
would
date,
be serious, that's why we did it.
Hearing notice to issue. Next one.
ACA number 17 and possible. ACA 530-2021. Musa Lewis Amure. Pamela Lewis Amure. Other participants, that's the absent now.
What did not sit at the last?
Hearing notice to issue.
As companies.
Next one.
That number 18, my lord.
Yes.
Sorry. It's not for tomorrow.
It's not for today.
Yeah, it's for tomorrow, my lord. That's
Oh, okay.
last one, my lord.
The last one of the ACA 23-24. Mrs. Bochi Innocentia, 1 Lope. Mr. Emeka Dashing Papa.
Other passes absence.
Party,
What's happening now?
representation,
The profound respect of the world. B.I. have here for the
DI,
B.I. have here for the competition.
yes,
Apologize for that.
right.
Although the motion makes party before it's not before. Gated working in the change. They are seeking. People this want to be able to serve, respond to their service. That's no less. From all attempt to stand.
The application,
They are seeking government response to self-protection, all laws and all their documents. And this you on the spot of that sending to FedEx or any other postal services. Don't have that touch. Sense of almost
that's great.
that's not the right thing.
Any children?
None.
Let's go back to the ruling.
This one I have the file.
It's yes, 368.
Yes. What number is that? Yes.
It's yes, 368. Mr. Mopadeyo Olatunde Osu. Mrs. Okure Peaceful.
Artist,
What's that? At present, sir.
representation,
Great Christian Lord, along Moses, SAGAMU,
Moses,
SAGAMU.
yes,
Now they appear for the petition.
Ọlọ́run, S-A-I, We're still on the petitioner's case, right?
Yes.
I'm just going to read the ruling today and you come back for continuation of hearing because I'm not feeling too good. This is a ruling in respect of the objection raised by Learned Counsel for the respondent on the admissibility of the statement of account sought to be tendered by the petitioner's counsel on the ground that the certificate of compliance deposed to in respect of the statement of account of Oshodi Oluwaseun domicile that First Bank ought to have been deposed to by the bank, which is First Bank and not the petitioner. Learned Counsel for the petitioner, on the other hand, argued that Section 84 of the Evidence Act 2011 does not provide for the mode of form which the certificate ought to be filed or produced and does not make provision as to who should sign same. Furthermore, Learned Counsel for the petitioner argued that relevance governs admissibility under the Evidence Act. I have examined the documents sought to be tendered. It is a bank statement that is signed, stamped in the original form. It is not a photocopy. However, there is no certificate of compliance issued on the face of the document by the said bank or attached to the said document except the one deposed to by the petitioner. The statement of account emanated from First Bank and not the petitioner who issued the certificate of compliance. Section 84 of the Evidence Act 2011 stipulates the condition for tendering computer-generated evidence. Section 84 further stipulates that the particulars and conditions of the device used to generate the document ought to be stated. It is therefore an officer of the bank who can issue a certificate of compliance in the instant case and not the petitioner. The purpose of Section 84 is to ensure proper authentication and validate the reliability of computer used to generate documents. See the case of Jubril and the Federal Republic of Nigeria, citation provided from the Law Pavilion report. See also Kubo and Dixon, citation also provided from the Law Pavilion reports. In the case of AG Federation and Anioe Buna, citation provided, the Supreme Court held, and I quote, Section 84 does not contemplate that the original letters and affidavits printed are computer generated. It would be absurd that such documents typed using a computer would be regarded as computer generated evidence. The court distinguished such documents from bank statements, which was considered to be computer generated, and therefore compliance with Section 84 of the Evidence Act is a must. The documents, now quote, the documents are 3 original letters and 1 affidavit. They are not computer, and I'm still quoting from AG of the Federation and everyone. They are not computer generated documents. The wordings of Section 84 does not contemplate that before an original official letter is tendered and admitted in evidence, the party tendering same must satisfy the conditions in the provision. Neither does the provision MB say same, where the admissibility of an original affidavit is an issue. It would be ridiculous to assume that a document which was typed using a computer is a computer-generated evidence. For example, it is the algorithm or data imputed by a bank officer into the bank's database that generates various informations on the statement of account of a customer. The bank statement is a computer-generated document which has to be certified by the officer to ensure that no one can allegedly or without authorization tamper with the source data as officially imputed by in the computer. Also, the certification must include that the computer was operational or in good working order when the document was generated by Ogunwuchi JSC pages 272 to 273. There is therefore no doubt in my mind that unlike letters that are typed using a computer, bank statements are more complex documents in the database of the bank and require certification by the bank. Ordinarily, banks should certify bank statements meant for court evidence in compliance with Section 84 of the Evidence Act. This was not done in this instance. The bank statement sought to be tendered without compliance with Section 84. It's therefore rejected and should be marked tendered and rejected for non-compliance with Section 84. However, this does not preclude the petitioner from obtaining a properly certified bank statement which complies with Section 84 of the Evidence Act for tendering subsequently. See the case of diverse assets management and Wema Bank citation provided on the law pavilion report. It's a 2023 matter Supreme Court. That is the ruling of the court. Right. Right. Need for continuation. As I said, I am a bit indisposed today, so I cannot go through the rigors of continuing with today. Date.
Give me a date. 55. 55.
55 for continuation, please. How many matters for this? 5 matters.
It's 5 million. So did you say that we need to go to the license?
It's just relatively this is Oladosu. That's what I do, Oladosu.
Parties,
That's something.
representation. Judgment. The petitioner Oladosu who presented the petition before this court on the 18th of January 2022 for the solution of the marriage, solemnized with the respondent, Jami Oladosu, on the 17th of December 2011 at the marriage registry at Bridgewater State, on the ground that the marriage has broken down irretrievably. The particulars of the parties are stated in the body of the judgment. The petitioner seeks dissolution on the ground of living apart, on the ground that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage. In paragraph 7 of the petition, there is no property being gained by the parties. The petitioner seeks a decree of dissolution of the marriage on the ground that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with him. The parties to the marriage have lived apart for a continuous period of 3 years immediately preceding the presentation of the petition. And the respondent does not object to a decree being granted, and order for custody of the children of the marriage to the petitioner under the terms listed in the petition. The evidence of the petitioner is that parties got married on the 17th of December 2011 at their daughter local government registry. She tendered the marriage certificate as PW1A. Parties cohabited at 7 Oladipo Street in the Greater Lagos State from 2011 to the 16th April 2016 when cohabitation ceased. The petitioner gave evidence that they constantly had misunderstandings which led to fights. There was an instance when the respondent battered her during their usual misunderstanding. They both fought and she dressed up and went to work. When she came back, she discovered the respondent had backed out of the matrimonial home. That was the day cohabitation ceased. The respondent has refused to resume cohabitation since 16th of April 2016. There are the two children of the union named Oladosu, Obato Fadera Aliyah, born on the 23rd of March 2012, and Oladosu Adewale Jama, born on the 21st of August. The petitioner testified that the respondent abused her physically on several occasions. Shortly after they had their child, he abused her physically, emotionally, and psychologically. On such occasions, she would inform his parents who would rebuke him and condemn his attitude. Sometime in December 2015, the respondent beat up the petitioner to stupor and destroyed her phone. The petitioner reported the incident to her father-in-law, who advised parties to be patient with themselves. On the 16th of April 2016, the respondent physically abused the petitioner while she was bathing. He was furious because she fried the plantain he brought. He took the intervention of his younger brother to rescue the petitioner from his cause. The respondent ran to the petitioner, whose towel fell from her body, and he continued to beat her in the presence of his brother. She escaped the second time naked in the presence of her brother-in-law. She testified that she has single-handedly been responsible for all the needs and education of the children of the marriage. She tendered copies of receipts of medical bills, school fees as exhibit PW1B1 to 20. On the 13th of June, the respondent attempted to pick up the children from school without the knowledge of the petitioner. She informed the school that she pays their bills and they should not be allowed to pick them up. The petitioner reported the incident at the office of the public defender in Surulere, Lagos State. To stop the respondent from taking the children without her knowledge, the petitioner was given a letter of invitation to hand over to the respondent. On our way to deliver the letter, she got a call from the children's school that the respondent had possibly taken the children away. It took the intervention of the policemen at the police station in Inupedu to get the children back to the petitioner. He was advised by his lawyer to allow the children who are minors to remain in the custody of their mother. The respondent thereafter informed the petitioner that if she lives with the children, he will not take responsibility for the children and he will not communicate with them again. The respondent blocked all means of communicating with them. The petitioner tendered the photocopies of the letter from the office of the public defender in Surulere, and same was marked, tendered, and rejected. Court ruled that the letters are from the public body and not duly certified. Case of Ozurike and Edoze cited. The documents were marked, tendered, and rejected. The petitioner urged the court to dissolve the marriage and grant her full custody and access and visitation rights to the respondent. Petitioner urged the court to mandate the respondent to pay for the education of the children in the tune of 100,000 per child on a monthly basis. At the close of the petitioner's case, Learned Counsel Yomi Adesoju Esquire addressed the court and submitted that the petition was filed on the 18th of January 2022. Cohabitation ceased in April 2016. She relied on Section 15(2)(f) of the Act, Matrimonial Causes Act. In the case of Adequenusi and Adequenusi, addition provided, the Court of Appeal held that by the provisions of 15(1) of the Act, the petition under the Act by the party or the decree for the dissolution of marriage may be presented by either of the parties on the ground that the marriage has broken down irretrievably. See also the case of Ipanem and Ipanem, where the court held that to present such a precision that the marriage has broken down, where the court cited the rule of Section 15(1), 2 to A to F, 15(1) and 15(2) to F, which are reproduced in the body of the judgment. In effect, there are 8 grounds for divorce, and proof of one of these grounds are, in the eyes of the law, conclusive proof of irretrievable breakdown of the marriage when Ndukwe Ayawu this year, still in the case of Ekanema Nekani. Now, it is tried that matrimonial causes are sui generis and have its own rules, special rules. The petitioner who seeks the solution on the ground that the marriage has broken down must give credible evidence to support the claim. So even if the case is undefended, the petitioner must still give evidence to the reasonable satisfaction of the court. Say the case of Uzuamaka and Uzuamaka. I have reproduced part of that in the body of the judgment. The onus is therefore on the petition and the petitioner to prove what he alleges. See Oriri and Oriri, see also Buntoyinbo and Buntoyinbo, where the court held that it would be in the interest of the society that divorce is not granted unless the court is fully satisfied upon unassailable facts that its grant is the only remedy to the marriage. The petitioner relied on 15(2)(f). The evidence is that cohabitation ceased on the 16th of April 2016 due to the inhuman torture and treatment meted to her by the respondent. The petition was filed on the 18th of January 2022. The evidence establishes that the parties have lived apart for over 3 years before the presentation of the petition. The court will grant the solution where parties have lived apart for 3 years. The court has no discretion to exercise and will dissolve the marriage without fault finding. When 15(2)(f) is proved, the court may dissolve the marriage without fault finding. See Omotunde and Omotunde. I find the fact of living apart for more than 3 years before the presentation of the petition proved to the reasonable satisfaction of the court. When 15(2)(f) is proved, the court need not consider other matrimonial offenses and will grant the solution on the fact of living apart for the continuous period of 3 years before the presentation of the petition. The petitioner has established his case with the reasonable satisfaction of the court. On the issue of custody, the courts are guided by section 71(1) of the Act, which provides that in proceedings with respect to custody, guardianship, welfare, advancement, or education of the children, the court shall have regard to the interests of these children as paramount consideration. And subject thereto, the court may make such order in respect of those matters as it seems thus. See the case of Alabi and Alabi as well. The court will consider the welfare of the child, his moral and physical upbringing, including his mental state. See also the short and the short citation provided. The petitioner testified that there are 2 children of the union named in the petition. They are both in the custody of the petitioner. The petitioner urged the court to dissolve the marriage and grant her full custody. Once the respondent has access and visitation rights, in the totality of the evidence before me, I am satisfied of the irretrievable breakdown of the marriage pursuant to 15(2)(f). I hold as follows. A decree NISA is granted dissolving the marriage sudden night between the parties on the 17th of December 2011 at the marriage registry. What are the daughter of the state Nigeria? The decree NISA shall become absolute 3 months from today. There is no contrary order of this court. The court hereby grants custody of the 2 children of the marriage to the petitioner. The respondent shall have right of access and visitation rights to the children twice a month. The petitioner shall have full custody of the children during the holidays. The respondent shall, however, not take or permit the child to be taken outside the state in which he resides without seeking and obtaining the consent of the petitioner, which consent shall not be unreasonably withheld. The respondent shall be responsible for the education of the children and the school fees must be paid before the commencement of the school term. The respondent shall be fully responsible for the maintenance, feeding, and upkeep of the children by paying a minimum of 80,000 naira for the 2 children on a monthly basis, subject to a review every 2 years until the attainment of 21 years of completion of the university education, whichever is later. If the respondent fails to fulfill his obligations as ordered by the court, it loses his rights, his visitation rights, and rights of access. to the children until the obligations are fully met. The petitioner shall continue to provide accommodation for the children as a contribution towards their obligation. That is the judgment in the case of Olajuwon and Olajuwon. Next one, please.
Number 2, this says, once it's partly also Anama. This Mr. Anama. It's Mark Philip, my lord.
What?
Mark Philip. You responded, I'm sorry. Yes, Mark Philip.
Parties, representation,
Say you just go out, man. Proceed with what?
who's on next list? Anama.
Yes, ma'am.
The petitioner Chizom Anama presented a petition before the court of the 2nd of May 2023 for dissolution of the marriage. Solemn night with the respondent, Mark Philip Anama, on the 24th of November 2015 at All Saints Cathedral Church, Onitsha, Anambra State, Nigeria, on the ground that the marriage has broken down irretrievably. The petitioner Chizom aborted the Anama rights. Particulars of the parties are stated in the body of the judgment. The facts upon which the petition is predicated is that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent, and the parties have lived apart for a continuous period of 3 years, immediately preceding the presentation of the petition. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in pages 4 and 5 of the case file. The petitioner seeks dissolution of the ground that the marriage has broken down irretrievably and custody of the 2 children of the marriage. Evidence of the petitioner. The petitioner gave evidence, global residence, testified that the respondent is a husband. Parties got married on the 21st of November 2015 at the All Saints Cathedral Church, Onitsha, Nigeria. She testified that the original marriage certificate was lost due to the fact that she moved from one place to the other. She tendered the certified true copy as exhibit of the U1A. The petitioner testified that parties cohabited after the marriage had put in Togo Drive was that as about Delta. There are 2 children of the marriage named Daniel Anama and Deborah Anama. Cohabitation between the parties ceased in March. On the 29th of March 2017, the petitioner gave evidence that the marriage has broken down irretrievably. The respondent committed armed robbery. He was caught, convicted, and sentenced to death by the court. She testified that she cannot continue to be called the wife of a convict. She tendered the certified true copy of the judgment delivered on the 30th of July in charge A 636/2018 as XBPW1B. The petitioner testified that she did not fully deny to bring the petition. She testified that the children of the marriage are with her parents in the first child, is in senior secondary school, and the school fees is 75,000 naira, whilst the second child is in JS1, and her school fees is 45,000 naira. She pays their school fees. She's responsible for their feeding on a monthly basis. She buys provisions of 50,000 naira for them and pays 600 naira on a daily basis for their school meals, which is about 22,600 per month. They spent 1,000 naira a day for transportation, which costs about 44,000 per month. She also spends 20,000 for medicals whenever they need analysis. There is also provision for HMO in the company where the petitioner works. Petitioner owed the court to dissolve the marriage and grant her custody of the children. At the close of the petitioner's case, an counsel B.O. Esquire addressed the court and submitted that the petition was filed on the 19th of November 2021. It relied on section 15(2), C and E and F of the Act. And the counsel submitted that the respondent was arrested in 2017, granted bail and sentenced to death. Such conduct exhibited by the respondent is unreasonable for the petitioner to continue in the marriage. She has been responsible for the children and will continue to take care of the children of the marriage. All processes were duly filed on the respondent, but he did not defend the petition, nor lead evidence. In matrimonial proceedings, the burden is on the petitioner to give credible evidence to the reasonable satisfaction of the court in the case of annuity and annuity. The petitioner must be down for one or more of the facts stipulated in 15(2)(8)(h) of the Act, or else the petition will be dismissed. See also a wrong premier and a wrong premier. I have reproduced in the body of the judgment 15(1) and 15(2)(8)(h). The onus is on the petitioner to ascertain to prove the facts as alleged. See also the case of Ogunjoyinbo, where the court held that it would be in the interest of society that divorce is not granted as a matter of course, but upon unassailable facts that it's granted. It's the only remedy to the marriage. In other words, the jurisdiction of the court to dissolve the marriage is one which should be exercised, which should not be readily applied because such jurisdiction involves the status of the parties. Accordingly, public interest demands that the marriage bond should not be set aside without strict proof on the grounds alleged and without painstaking and strict judicial inquiry. First, DC, the petitioner relied on 15(2)(e) of the Act. Evidence is that cohabitation ceased on the 30th of November after conviction and he was sentenced to death. The petition was filed on the 2nd of May 2023. From the pleadings and evidence before the court, the parties have lived apart for more than 2 years. See the case of Uzochukwu and Uzochukwu citation provided. The court held that it is immaterial who has forced the parties to live apart. Once 15(2)(e), under section 15(2)(e), the court, it does not permit the court to go on a fault-finding expedition. Omotude and Omotude also cited, in which the Court of Appeal expressed a similar view on section 15(2)(f) of the Act. See also Ibawuchi and Ibawuchi, Olubu and Olubu, all cited in the judgment. The petitioner has established a case to the reasonable satisfaction of the court on the fact of living apart for more than 2 years before the presentation is preceding the presentation of the petition. Where 15(2)(e) is proved, the court may dissolve without fault finding. The petitioner relies on 15(2)(c) also, and urge the court to hold that the marriage has broken down if it should be, on the fact that the petitioner cannot reasonably be expected to live with the respondent, who is currently on death row. He was charged and found guilty, eventually convicted for armed robbery. The respondent, as at the time of writing this statement, is in the Nigerian Correctional Center along Okwere Road, Wari South Local Government Area, Wari Delta State. Section 15 of the Matrimonial Causes Act makes supplementary provisions to 15(2)(c). Under 16, it provides that without prejudice to the generality of 15(2)(c), the court hearing the petition for decree of dissolution shall hold that the petitioner has satisfied the court of the fact mentioned on 15(2)(c). if the petitioner satisfied the court. A, that since the marriage, the respondent has within a period of time not exceeding 5 years suffered frequent convictions for crime in respect of the respondent, in respect of which the respondent has been sentenced in the aggregate to imprisonment for not less than 3 years. I have no doubt in my mind that the conduct of the respondent towards the petitioner is one which she is not reasonably expected to continue to live with in the circumstances, and I find 15(2)(c) proved by the petitioner against the respondent to the reasonable satisfaction of the courts. On the issue of custody of the two children, as I said, the courts are guided by section 71(1) of the Act, and the court will consider the ages of the children when awarding custody. See Uduchi and Uduchi citation provided. See also Alabi and Alabi citation provided. And also the case of Nana and Nana, where the court considered that the paramount interest of the children should be the court's concern at all times. The children of the married are in the custody of the petitioner, and the respondent is currently on death row, having been sentenced to death for armed robbery. It is in the best interest of the children that they remain with their mother. On the totality of the evidence before the court, I'm satisfied that the petitioner has established irretrievable breakdown of the marriage. Also, to 15(2)(b) and (c) of the Act. A decree is granted dissolving the marriage solemnized between the parties on the 24th of November 2015 at the All Saints Cathedral Church, Onitsha, and Anambra, Lagos State. The decree shall become absolute 3 months from today. There is no contrary order of the court. The court grants sole custody of the two children to the petitioner. The petitioner shall be responsible for their upkeep and general advancement. The petitioner shall be responsible for the school fees until completion of the university or tertiary level of education. That is the judgment of the court. I'm sorry. I don't know if you can hear me. I said I'm indisposed. I'm in the middle of reading judgments. Next one.
This year, Mr. James,
What number?
number 3.
Number 3.
Mr. James Thompson, Olatokunbo, Ame Maria, Orasu Nisi, Odinisola, my Lord, that is absent, my Lord.
Representation.
E.A. Royal Salami. Uri Victor. E.U. Adola.
Kuriola Salami. Holding.
Uri Victor. E.U. Adola.
B.O.
E.U.
How many left, please? Registrar. After this.
This gentleman, the one I told you. This one I told you. This one.
You have called number 3, right?
Yes, madam.
Thank you. That's what you 2020.
What?
2022. That's
Right.
number 3.
Parties? Representation?
Stress is that. PA, your last one. Putting P and your last.
P.O. Agbola or P? P. The petitioner presented a petition before this court on the 18th of January 2022 for dissolution of the marriage contracted with the respondents on the ground. Can I have water, please? On the ground that the marriage has broken down. Water. Leave it please. On the ground that the marriage, which was conducted on the 10th of November 2017 at the Federal Registry, Italy, has broken down irretrievably. Particulars of the parties are stated in the body of the judgment. The petitioner pleaded circumstances and facts into the breakdown of the marriage in paragraph 11 of the petition. The petitioner seeks the following orders, the solution of the following orders. That the parties have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition, and that the respondent has willfully and persistently refused to consummate the marriage. The petitioner seeks the solution on the ground that the marriage has broken down irretrievably. The respondent has willfully and persistently refused to consummate the marriage. The respondent has seizure of at least 3 years, 1 year, from 12 November 2017, immediately preceding the presentation of the petition, and the petitioner and the respondent have lived apart for a continuous period of at least 2 years, from 12 November 2017, and the respondent does not object to the being granted. Oh, the respondent has lived apart for a continuous period of at least 3 years, from the 12th of November 2017, immediately preceding the presentation of the petition. Evidence of the party is that the petitioner, a teacher, gave evidence that he resides at 32 Shotayo Hill Street off Oduduwa Street, Surulere, Lagos State. He testified that the respondent is his wife. The parties got married on the 10th of November 2017 at the marriage registry for Lagos State. The marriage certificate was tendered as XVPW1A. The petitioner gave evidence that the respondent flew into Nigeria a few days before the wedding. After solemnization of the wedding, parties retired to the residence of the petitioner at 12 Orlando Street, Ijesha, Lagos State, where they both spent a few hours together with their families. The respondent left to stay with her stepmother elsewhere that same day and traveled back to the United Kingdom on Sunday, the 12th of November 2017. Exactly 2 days after they got married. They did not cohabit after the marriage. There is no child of the marriage because parties never consummated the marriage. The petitioner gave evidence that they were together in Nigeria for 18 months, dating before she traveled to the United Kingdom for work. He testified that the parties got married in order to seal their relationship. How many of this? Right. Because it does not want to have children out of wedlock. The respondent failed to go on with their plans and refused to resume cohabitation or communicate or take steps to join for the petitioner to join in the United Kingdom, despite all efforts by the petitioner for parties to build a family together. The petitioner urged the court to dissolve the marriage as parties have not consummated the marriage, and the parties have lived apart for 3 years. Learned counsel for the petitioner urged the court to foreclose the right of the respondent to cross-examine the petitioner and to close the case for want of diligent prosecution. The court granted the said application and closed the case. At the close of the petitioner's case, learned counsel for the petitioner, Peter Agbola, Esquire, addressed the court and submitted that the marriage has broken down irretrievably as the parties have lived apart from the 12th of November 2017 to the 18th of January 2022. The petition was filed over 4 years, after 4 years of living apart. Learned counsel relied on 15(2)(f) of the Act and submitted the case of Omotunde and Omotunde citation provided. It is right that the petitioner who seeks the order of the court to dissolve the marriage on the ground that the marriage has broken down irretrievably pursuant to 15(1) of the Act must be able to bring himself within one or more of the facts stipulated in 15(2)(a) to h of same. The court places a burden on the petitioner which he must discharge, even where the petition is undefended. See the case of Uzoke and Uzoke citation provided. See also section 82(1) and 2 of the Matrimonial Process Act, which is in the body of the judgment. Furthermore, the court shall therefore hold that a marriage has broken down if one or more of the facts stipulated in 15(2)(a) to h of the Matrimonial Process Act is proved to the reasonable satisfaction of the court. See also the case of Bakari and Bakari citation provided from the law pavilion of the courts. I have cited in the body of the judgment the rule of 15(1) and 15(2)(a) to h of the Act. The burden is therefore on the petitioner to give credible evidence to the reasonable satisfaction of the court. See the case of Anuyeke and Anuyeke citation provided. The petitioner relies on 15(2)(f). The petitioner testified that the parties have lived apart since the 12th of November 2017, when the respondent relocated to the United Kingdom, and she has deliberately refused to resume cohabitation or communicate with the petitioner. The petition was filed on the 18th of January 2022. The evidence before the court establishes the fact that the parties have lived apart for more than 3 years preceding the presentation of the petition, and where parties have lived apart continuously for 3 years, immediately before the petition was filed. The court will go on to consider. The court will not consider whose conduct led to the breakdown of the marriage, but will grant dissolution of the marriage, also to 15(2)(f) of the same. In the case of Omotunde and Omotunde, where the court held that the provision is mandatory and the court has no discretion to exercise. This section has the absence of the fault element characteristic of other matrimonial offenses. The law behind 15(2)(f), as far as living apart is not concerned, is not interested in right or wrong, or guilt or innocence of the parties. Once the parties have believed the part, the court will grant a decree. End of quote. See also Ajidawan and Ajidawan. I find 1512 by the petitioner against the respondent who relocated to the United Kingdom and refused to resume cohabitation. On the totality of the evidence before the court, I am satisfied that the petitioner has established an irretrievable breakdown of the marriage pursuant to the 2 record same. A decree 9 is hereby granted, dissolving the marriage, solemnized between the petitioner and the respondent on the 10th of November 2017 at the Federal Marriage Registry for Illegal State. The decree 9 shall become absolute 3 months from today if there is no contrary order of this court. That is the judgment of the court. Right. How many more?
Yes, madam.
Mr. Orozco Nolani.
Question of the
CONA. Case of Olanrewaju and Olanrewaju. The judgments. The petitioner presented the petition before this court on the 10th of February 2022 for dissolution of the marriage, solemnized with the respondent on the 29th of December 2016 at the Federal Marriage Registry on the ground that the marriage has broken down irretrievably. The particulars of the parties are stated in the body of the judgment. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 13(e)(g) of the petition. The prayers of the petition are also stated in the body of the judgment. Evidence of the petitioner. The petitioner, an entrepreneur, gave evidence upon presentation of her international passport and national identification. She testified that she resided at B1 January Park Football Club. She testified that the respondent is her husband, parties got married on the 29th of December 2016 at the Federal Marriage Registry. The marriage certificate was admitted as PW1A. The petitioner gave evidence that there is a child of the marriage named Jaden Olanrewaju male, born on the 18th of July 2018. On the 31st of December, the respondent sent the petitioner out of the matrimonial home with the only child of the marriage. She testified that the respondent abused her physically, emotionally, verbally, and he engages in extramarital affairs. The petitioner gave evidence that the respondent accuses her of being responsible for the son's disability. The son was diagnosed with cerebral palsy. She tendered documents showing the medical condition of the child and same was admitted as PW1B124. The certificate of compliance as PW1C 1-20. She testified that she has single-handedly been responsible for the medical procedure, therapy session, and therapy session of the child. She had to employ a nanny for the child, an occupational therapist, a physiotherapist, and also a speech therapist. The marriage was devoid of peace. She urged the court to dissolve the marriage and grant her sole custody of the child, monthly maintenance of 150,000 and yearly rent at the rate of 500,000. At the close of the petitioner's case, the net counsel PT additional Esquire addressed the court and submitted that the marriage has broken down as the parties have lived the 5th of December 2020 to the 10th of February 2022 when cohabitation ceased. He relied on section 15(2)(d) of the Act and submitted the case of Akinbuwa and Akinbuwa for the court's consideration. In matrimonial proceedings, it is mandatory that the petitioner who seeks the order of the court to dissolve the marriage on the ground that the marriage has broken down irretrievably pursuant to 251 must be able to bring himself within one of the more of the facts stipulated in 15(2)(a) to H. I have cited in the body of the judgment the whole of 15(1) and 15(2)(a) to H. The burden is on the petitioner is to give credible evidence to the reasonable satisfaction of the court. See the case of Judgewell and Judgewell 2022 citation provided, where the court held that where the court reminded us that the standard of proof is provided for in section 82(1) and 2 of the Act, and it is cited in the also see both the EK and EK 2018 citation provided, where the court held that one or more of the ingredients under 15(2) must be proved. Even must be proved before the court can dissolve the marriage, even if divorce is desired by both parties. The petitioner relied on 15(2)(d) of the Act to establish the irretrievable breakdown of the marriage, pursuant to 15(1). The petitioner pleaded added evidence to establish constructive desertion on the part of the respondent. The respondent sent the petitioner packing on the 31st of December 2020. The respondent sent her out of the matrimonial home with the only child of the marriage. The petition was filed on the 10th of February 2022. This is over 1 year of the being part. By 15(2)(d) of the Act, the court is bound to hold that the marriage has broken down if it is respondent that if it is established that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. So what is desertion? Desertion is a withdrawal of support and cessation from cohabitation without the consent of the other spouse and with the avowed intention of abandoning allegiance, fidelity, and responsibility and remaining separated in perpetuity. Put differently, desertion means abandonment or voluntary withdrawal from all marital obligations by a married person without just cause. Thus, to establish allegation of desertion, the petitioner must establish physical separation, avowed or manifest intention to remain separated in perpetuity, absence of any good or just cause or justification. It is noted that the law gives recognition to 2 types of desertion, namely single desertion and constructive desertion. In the former, it is the absentee spouse who has abandoned the matrimonial ship and abdicated responsibility for requisite duties, while in the latter, it is the spouse who remains aboard the matrimonial ship who is in desertion, in that the said counsel has, by his conduct, expelled the other. Anegi and Anegi, Masood Abdul Rahman Otegoraji at pages 27 to 29. I find constructive desertion under section 15(2)(d) by the petitioner against the respondent. On the issue of custody, there is a child of the marriage named James J.J. Olaruwaju, who was born on the 18th of July 2018. Upon medical examination, he was diagnosed with mild cerebral palsy. He lives with the petitioner. The only child has a medical condition that requires special requires the petitioner or the court to grant as soon possible and the respondent visitation rights. He urged the court to compel the respondent to take up his responsibility as a father for the welfare of the and maintenance of the child, also education inclusive. When considering issues of custody. The courts are guided, as I have said earlier, by the provisions of section 71(1), which is reproduced in the body of the judgment. Also, see section 1 of the Child Rights Act, where the court held that all actions where the children are concerned, whether undertaken by an individual, public or private body, or administrative or legislative authority, must be in the best interest of the child. Also, see the case of Davidson and Davidson to that effect, and also Oduche and Alabi, where the courts have held that the court must consider what is the best interest of the children in each circumstance. The court must also consider their ages and all other factors which I have quoted. I will therefore make the appropriate orders subsequently. On the totality of the evidence before the court, I am satisfied that the petitioners established the irretrievable breakdown of the marriage, pursuant to 15 to F, pursuant to 15 to D of the Act. A decree NISA is granted dissolving the marriage of the parties, solemnized on the 29th of December 2016 at the Federal Marriage Registry. The decree NISA shall become absolute 3 months from today if there is no contrary order of the court. The court hereby grants sole custody of the child, J.D. Niruwa Jr., on the 18th of June 2018 to the petitioner whilst upon in the following schedule. The respondent shall have access to the child 1 week every month. The respondent shall have access to the child 1 week during the short holiday and 2 weeks during the long holiday. The respondent shall provide a telephone for the child so as to enable him have access to the child via telephone. The respondent shall pay the sum of 150,000 monthly as maintenance and upkeep from January 2022 to the date of judgment, and same amount from the date of judgment, considering the fact that the only child has been diagnosed with cerebral palsy and has special needs. The respondent shall pay to the petitioner the sum of 300,000 naira. Yes, the respondent shall pay to the petitioner the sum of 300,000 naira yearly, or 50% rental value for a decent 2-bedroom flat for accommodation for the only child of the marriage, whilst the petitioner will take up the responsibility of the remaining 50%, subject to 20% increase every 3 years. The petitioner shall be responsible for the education of the child up to university level, whatever form is the respondent shall be responsible for the education of the child up to university level, whatever form of education is required for a child with special needs. The petitioner may apply for an upward review and variation of the maintenance sum where circumstances change, pursuant to Order 73 of the Matrimonial Procedures Act of the Federation. That is the judgment 2004. That is the judgment of the court.
That's what
Yes, Raised in court. Judgment. On the case of Banjo and Banjo. The petitioner presented a petition before this court on the 10th of October 2023 for dissolution of the marriage solemnized by the parties on the 1st of October 2008 at the Apostolic Church, Kosovo, Oyo State, Nigeria, on the ground that the marriage has broken down irretrievably. Particulars of the parties are stated in the body of the judgment. The fact upon which the petition is predicated is that the parties have made the part for a continuous period of at least 3 years in the presentation of the petition. The petitioner's reliefs are stated in the body of the judgment. Evidence of the petition. Petitioner testified that she got married to the respondent on the 1st of October 2008 at the Apostolic Church in Oyo State. The marriage certificate issued was admitted as Exhibit PW1. B was the copy of the National Insurance. NIN was admitted as PW1A. The petitioner testified that they were always having arguments, and one of such arguments led to the eventual abandonment of the matrimonial home by the respondent. She testified that due to their incessant arguments, the respondent would stay away from home and come home only during the weekends. He eventually came home on the 8th of December 2018 demanding to be fed. The petitioner told him that there was no gas to cook any meal and she had been ill. He flared up and started arguing with her as usual and then slapped her. The neighbors tried to intervene due to the noise from their house. He eventually packed his clothes and abandoned the matrimonial home, never to come back again. The petitioner testified that the child of the marriage lives with her. She wants sole custody and wants the respondent to have visitation rights of the child. She wants the respondent also to take up his responsibility as a father. She also wants the respondent to pay the school fees and medical bills of the child. Learned counsel Uyukiri addressed the court and submitted that the parties have played their part. Since the 8th of December 2018, he relied on 15(2)(f) of the Matrimonial Process Act. In matrimonial proceedings, it is mandatory that the petitioner will seek the order of the court to dissolve the marriage on the ground that the marriage has broken down irretrievably pursuant to 15(1) to bring himself within one or more of the facts stipulated in 15(2)(a) of the Act, which is reproduced in the body of the judgment. The burden is on the petitioner to give credible evidence to the reasonable satisfaction of the court. Judge well and not judge well, cite the court should be provided where the court relied and cited section 82(1) and 2, which I have reproduced in the body of the judgment. Also see body Ike and Anita Ike when the court held that for a petition for dissolution to succeed, the petitioner has to prove at least one of the ingredients contained in the acts, even if in 15(2), even if it was his desire by both parties. So I think the one. But the petitioner relies on 15(2)(f), She testified that cohabitation ceased on the 8th of December 2018 after an argument with the respondent who slapped her for not cooking for him due to ill health. He packed his clothes and abandoned the matrimonial home never to return again. The petition was filed on the 10th of October 2023. This is about 4 years that the parties have moved apart. The evidence of the petition on the ground that the marriage has broken down is satisfactory and in line with section 15(2)(f). Where 15(2)(f) is proved, the court may resolve without court findings. See the case of the Motile and the Motile, where the court held that the provision is mandatory and the court has no discretion to exercise, as this section has the absence of court element characteristic of matrimonial offense. The law behind 15(2)(f), as far as living apart is concerned, is not interested in right or wrong, or guilt or innocence of the parties. Once they have lived apart, the court will grant a decree. But Article AGC at pages 62 to 63, paragraphs A to E. See also down and down citation provided. I find 15(2)(f) proved by the petitioner against the respondent. On the issue of custody, there is a child of the married, Victor Oluwaseun Banjo. He lives with the petitioner. She wants the custody and wants the respondent to have visitation rights. The petitioner also wants the respondent to take up his responsibility as a father for the welfare, upkeep, and education of the child. When considering the issues of custody, the courts are guided by section 71(1) of the Act, which provides that in proceedings with respect to custody, guardianship, welfare, advancement, or education of the children, the court shall regard the interests of these children as the paramount consideration, and subject to the court may make such orders as in respect of those matters as it thinks proper. Section 1 of the Child Rights Act 2003 provides that in all actions where the children are concerned, whether undertaken by an individual, public or private body or administrative or legislative authority, the best interest of the child shall be the primary consideration. The JCA case of Caldwell and Caldwell citation provided, as it then was. In Davidson and Davidson, the court also held that in proceedings with respect to custody, guardianship, welfare, and advancement of the child, the court shall regard the interests of the children as the paramount consideration. That is, the court cited section 71 copiously. Also, the case of Alabi and Alabi, citation provided, where the court held that the welfare of the children is of paramount consideration, and the degree of familiarity with the parent will also be taken into consideration. On the totality of the evidence before this court, I am satisfied that the petitioner has established the irretrievable breakdown of the marriage pursuant to the 10(2)(f) of the Act. A decree NISA is granted, dissolving the marriage, solemnized between the parties at the Apostolic Church, Bishop of Oyo State. The decree NISA shall become absolute. 3 months from today, there is no contrary order of the court. The court grants primary custody of the child, Victor Oluwaseun Banjo, to the petitioner with visitation rights to the respondent on weekends at a place agreed by the parties. The court hereby awards a sum of 400,000 naira annually to be paid by the respondent to the petitioner for the education, welfare, medical expense, and medical expenses of the child. The petitioner may apply for an upward review of variation of the maintenance sum where circumstances change, pursuant to order 73 of the matrimonial festival. There was also present in 2004. That is the judgment of the court. Right. Thank you.